This Honorable Court of Appeals of Tennessee is now in session.
Good morning. Welcome to the Court of Appeals on behalf of Judge McClarty and Judge Davis. You know, the arguments, even though we're on Zoom, they proceed pretty much like they do when we're all together in the courtroom. And if we have any technical problems, we'll stop and resolve them and finish out. So don't worry about that. There's no announcements. We'll begin. Mr. Hivner, would you please call the case?
Marleta Costner et al. Versus Maryville-Alcoa-Blount County Parks and Recreation Commission.
Okay, Mr. Wilson, you're the appellant, I believe. So you may begin.
Thank you, Your Honor. Ms. Marleta Costner was attending a concert in the Springbrook Park owned by Alcoa back in September 22nd of 16. There was a young lady that was a close friend of theirs performing that night. And so they came to hear her and to support her. And while walking back to the car to get a blanket, it's getting a little cool, she stepped in a hole. It turned out to be 26 inches deep, 6 inches wide, and 9 inches long. But it was covered with grass clippings, so she didn't see it. And when she fell in it, unfortunately, it broke a bone in her ankle that took doctors a considerable length of time to discover. In fact, they put her through, of all things, physical therapy on a broken bone in the ankle, trying to treat her. Finally, a doctor did discover the problem, and that being a broken bone in that ankle. She had to have 2 surgeries, extensive treatment, and it took a long time for this thing to get healed. This park, we filed suit. We've discovered that Alcoa owned this park, so we've initially filed suit against Alcoa in September of 17, just before the statute ran. Alcoa then filed an answer saying it wasn't their fault. It was the fault of the commission, a commission comprised of Alcoa, Maryville, and Blount County. They joined together to form what they advertised as a joint venture, and correctly so, because that's what the statute says too, that's what they formed. And this joint venture, this recreational commission, I'll just refer to them as commission throughout, was charged with operating all the parks owned by Alcoa, Blount County, and Maryville. So when they said that, we filed suit against not only the commission that they said was involved, but the other partners. And that's really what a joint venture is a partnership for a limited purpose, and that purpose was to maintain all these parks and operate them. So we filed suit against all the parties, not only the commission, but the people who control the commission. And that's the way it works. The proof showed that each of these entities, the city and the county, all provided a member to be on this commission, and they actually control it. The case rocked on until fall of that year of 17. The judge decided that the cities and the county didn't have any business being in this case, so they were let out by order. And of course, we couldn't appeal that because we still did have the commission as a defendant in the case. So under the rules, unless you've got all parties and all issues resolved, you can't appeal. So this rocked on then until January of 21, when the trial judge decided that the statute dealing with recreational use of property applied in this case, and that therefore, since Ms. Costner was there for recreation, the case should be dismissed. Problem with that is the statute that's cited, the recreational use statute, has a whole list of activities that give the owner of the land immunity. None of those are attending a concert at the park.
Mr. Wilson, this is Judge Davis. Did your clients not agree in response to either interrogatories or statement of undisputed facts? Did they not concede that they were there for recreational activity?
Yes. My client said that they weren't there for business. They were there for recreation. But the statute does not say all forms of recreation give immunity to the landowner. There's a specific list. And there is cases that say either that list or something very similar to that list. There's a case where one of the things is a horse riding horses. There's a case where a child was riding a bicycle and had a wreck, and the court said, well, that's close to riding a horse. But there's nothing in the statute that comes close to saying if you're attending a concert at a park that that gives immunity to the owner of the land or the operator of the land. Now, there's been a lot of noise made about the GTLA statute saying that the land has to be owned and operated by the party before they're liable. That was not the basis of the judge's decision in January of 21. In fact, he wouldn't go there. He says, I'm concerned about that because the argument put forth by my opponents was it didn't matter how awful the trap is set. Even if it was a hand dug well covered with grass, somebody fell in and died as a result, it wouldn't matter because they keep talking about the fact that you got to own and operate the land. That troubled the trial judge. He didn't like the sound of that. So he did not in fact rule in that January 21 decision that that statute applied that says it had to be owned and operated by. There's no case that I found that says going to a concert is anywhere close to any of these specific list of items shown in that statute. The fact that Alcoa owned this property, there's no dispute about that, and they have a duty to maintain that property. Even it says, the statute says that they can't come up with an agreement that will do away with that obligation unless someone provides the very thing that they're talking about. In this case, they did not maintain this property as a park accurately. That hole, by the way, was it was there at the time of the concert. It was there a year later, even though the manager of my brain went dead on me all of a sudden. This commission, the commissioner, the director of that commission says that they filled holes. In fact, the last time they filled holes was in February of that same year. And that, but he had never been out to this park to check it out, to see if what he had told his employees to do had actually been done. He didn't know for sure. Didn't know why the holes showed up. You'd think somebody in a park would try to figure out why we're having holes to show up in a park. I believe that's a duty of theirs because they're inviting people to come to a park. And Alcoa has a duty that's not delegable, as I read the statute, to maintain that park.
Was there any notice on the part of any of these parties you sued that hole was there?
Big hole, not to my knowledge, but they appeared in this park because they had a policy of filling the holes. But they didn't fill this one, and it was very close to the stage that they had set up for this concert. And they also, according to the manager of this organization, he says that they mowed it every week. Well, if they're over that with a lawnmower every week, they were in position to see that hole better than anyone else.
You have about a minute left, Mr. Wilson. You have about a minute left.
Oh, gosh. Thank you very much. I would simply say, Your Honor, that these parties were one organization. They were a joint venture. We did send notice of appeal to the commission, and we cite the statute that says a notice to one partner is notice to all. And I believe it's important, especially that we keep Alcoa in this case. I don't really care if Blount County doesn't want to stay in or Maryville doesn't want to stay in. They really did not have any hands-on activity with regard to this injury. So if they want out, I don't care. As far as I'm concerned, and looking at this, that means two less enemies I've got to deal with.
Thank you, Mr. Wilson. Your time is up.
Thank you.
You still have your rebuttal time later.
Thank you.
Now, I understand the argument for the appellees will be divvied up. So I don't know who goes in what order. So just take off and go with your agreement there.
Thank you, sir. My name is Shelley Wilson. I'm here on behalf of the city of Alcoa. My first argument to this court is the fact that the city of Alcoa should not even be a party to this appeal. We have had separate counsel all along. We were dismissed from the case in February of 2020. Of October of 2018. The case was not finally dismissed, which was the commission being the last party dismissed in January of 21. The appeal was filed on February 22nd of 2021. We were not named as a party in the notice of appeal. The certificate of service signed by Clifford Wilson indicated on the form that it was to the commission and to Benj Louderback as their attorney. According to Rule 5A, Mr. Wilson was required, or the appellants, to serve us with notice within 7 days or by March 1st of 2021. We were not served, well, we were never served with notice of appeal, but the reason we found out about it was receipt of the appellant's brief on July 1st. It was filed with the court on July 1st. That was more than 127 days late. In other words, after March 1st of 2021. So we were never properly served. There's argument that the Tennessee Partnership Act would apply, but that applies to for-profit businesses, not for government entities like the city of Alcoa, which was admitted in the motion for summary judgment. The plaintiffs at the time, appellants, did not file any brief in opposition to the summary judgment that was filed by the city of Alcoa. They didn't file anything in dispute of the facts. And the final order in that case, as to the city of Alcoa on page 31 of the record of appeal. And by the way, the only record of appeal here is with respect to the city of Alcoa's position is the brief filed by the city and this order. There is no hearing transcript and nothing in writing filed by the appellants in the trial court level. This court specifically finds the city of Alcoa has negated essential elements of the plaintiff's claims raised against it. This court finds that the appellants Plaintiffs failed to respond to the City of Alcoa's statement of undisputed material facts. This court specifically finds that the City of Alcoa has proven that it does not control Springbrook Park and that it is therefore immune from suit pursuant to the provisions of the Tennessee Governmental Tort Liability Act, as the same are found at TCA 29-2201 et sec. The court finds that while the City of Alcoa does own the property at issue, that being Springbrook Park, the plaintiff's failure and inability to prove that the City of Alcoa also controlled the park is fatal to the complaint raised against the city. This court finds that the City of Alcoa has proven this undisputed fact and that plaintiffs have not come forward with any evidence to the contrary. Therefore, the court granted it as a matter of law. Your Honors, there is no authority for the plaintiff to be moving against the City of Alcoa in this appeal. And as for any joint venture or partnership that they argue, that is not controllable in this case. First, they never raised it at the trial court level. It's just now being raised at the appellate level. The city, again, is formed, the commission is formed under interlocal agreement, which is controlled by the Governmental Tort Liability Act. Let's see. As a separate legal entity, the commission is a legal person and notice to it cannot constitute notice to any other governmental entity. Again, we are not a for-profit entity, and therefore we are not subject to the Joint Partnership Act. And that's all I have at this time, Your Honors. We believe that we shouldn't be a party, that we weren't properly noticed, that the GTLA applied, the court properly applied it. There was nothing in response in opposition to the motion that was filed by the city. There is no hearing transcript. There's nothing. And as far as joint partnership or any other excuses used other than the GTLA that applies here, they are not applicable. Thank you very much.
Thank you, Ms. Wilson. Next.
I'll take up that mantle at this point, Your Honor. And may it please the court, my name is Benjamin Lauterbach. I had the privilege of representing the city of Maryville in this matter, as well as the entity I'll refer to, if it pleases the court, as the commission or the Parks Commission. Let me jump off, if I may, with the city of Maryville. I echo Mrs. Wilson's comments as it relates to the city of Alcoa and the timeliness of the appeal. The city of Maryville was not included on the notice of appeal by pure happens chance, because I represented the commission as well. I received that, and that prompted my concern over, who are you actually appealing against? Because my other client, the city of Maryville, isn't listed. Lo and behold, I get a brief, and it's included in the brief, which prompted the motion to dismiss in this court. I suspect took it under advisement and decided it would like to hear argument on it. And here we are today. So, and I certainly understand that position. There's another argument as it relates to the city of Maryville on timeliness grounds. It was not initially sued. Ms. Wilson's answer on behalf of the city of Alcoa did not name the city of Maryville, nor did it name Blount County. It only named the commission. And the 90-day extension, if you will, on the statute of limitations that applies when comparative fault defendants are named would not apply to the city of Maryville, because it wasn't named as an affirmative defendant by the city of Alcoa. Therefore, the 12-month statute of limitations period we respectfully submit would apply as to the city of Maryville that's set out in the Governmental Tort Liability Act. I'm glad to answer any questions as it relates to the city of Maryville. I will quickly echo Ms. Wilson's comments as well on the joint venture partnership issue. It's important to note there have been multiple complaints filed through amendments. Not one referenced partnership. Partnership came up for the first time on appeal, and it's our position respectfully that that is too late. They've missed the game on that one, and we respectfully submit that issue be brushed to the side quickly as it relates to all the appellees in this case. My second client in this case, the commission, we moved that the appeal should be dismissed against it as well. The trial court correctly noted several issues that weren't independently the dismissal of the commission. I don't disagree necessarily with Mr. Wilson's argument in his opening portion of this discussion that the trial court struggled a little bit with the concept of these commissions being put together and then an argument being raised, you don't own it, you don't own the property. The fact of the matter is that's a legislature issue. The legislature has set out the Governmental Tort Liability Act, and it's held that governmental entities must own and control. It is undisputed that the commission did not own this piece of property, Springbrook Park. There's no dispute whatsoever on that issue. The trial court went further, and it held that there was no notice, and this court's already picked up on that. I heard there was no notice to the commission of any problem or issue as it related to these holes or a hole. We're not even sure where this particular hole was. We know where the plaintiffs say it was, and we also know the plaintiffs say they walked over it a couple times, as well as their key witness, a friend of theirs, and never saw it themselves. The witness, and this is cited in our brief, specifically stated he couldn't see it unless he got down on his knees and started pulling the grass back. Even standing over it, bending over at his waist, he couldn't see it. So we respectfully submit the commission should be out under the Governmental Tort Liability Act, both on the ownership issue and the notice issue. As it relates to the recreational use statutes, we also submit these apply to the commission. It's important to note that the multiple amended complaints did not reference gross negligence. There was no plea or pleading that stated gross negligence, as we submit should have occurred if you were wanting to overcome the immunities that would attach under the recreational use statute. This clearly is a park. Hiking is specifically listed under the statute. There's no argument where I'm going to make that there was hiking going on, but if a bicycle is the equivalent of riding a horse, then walking is the equivalent of hiking, we would respectfully submit. This activity, the recreational use activity, and the law, the cases that have evolved over the years, both through this court, the Tennessee Supreme Court, the Sixth Circuit, and the U.S. District Courts, where particularly TVA is involved in the federal matters, have uniformly held that this statute doesn't have to specifically say the action. And that's the pretty clear-cut black and white law on that particular issue. She was there to go and observe a concert. Yes, no dispute there. She was in the process of walking back and forth, frankly, a couple times before she stepped and rolled her ankle or whatever she did. The cases, there are cases out there that cover walking and being injured when attending a cultural event. There's one specifically, the Matthews case that I've cited in my brief, a case out of this court, 2005 case out of this court, where the plaintiff was walking to attend an archaeological event, a cultural event, if you will. When walking on a sidewalk to get there within the confines of the park, there was a trip and a fall that occurred, and the court held the recreational use statutes apply because there was no evidence of gross negligence. We submit that the pleading should have argued gross negligence if you're going to overcome the recreational use statute, and they clearly did not. I'm glad to answer any questions the court may have. I've cited multiple recreational use cases that have dealt with the gamut. There's tragic and very sad cases of flooding that are involved that this court sadly had to deal with just this past year involving the recreational use statutes and the applicability of the law. There are cases where children have fallen off cannons in national battlefields and are injured as a result of that. There's certainly no reference to climbing on or falling off of cannons in the statute, but the courts have uniformly held that those type of activities, when in a park, be it a state park, a national park, TVA, boat ramp type of park, the recreational use statutes in the state of Tennessee apply. Again, I'm glad to answer any questions, or I can pass my time on to Mr. Garrett as well. But it's our position in totality that the trial court got it exactly right. It perhaps struggled with some of the mechanisms of how it got it right, but it definitely got it right, and it understood that its mandate was to follow the law and the case law that exists, as well as the statutory law that exists. And we respectfully submit that the appeal should be dismissed as to the City of Maryville and the Parks Commission. Thank you.
Thank you very much. Mr. Garrett.
Thank you, Your Honor. Craig Garrett here, and I represent Blount County. And I have operated under the labors of my colleagues, Mr. Lauterbach, Ms. Wilson, in this case, the best brief I've ever written, because I adopted their briefs. And that's what I'm doing this morning. My arguments on behalf of my client are identical to the arguments that Mr. Lauterbach has made on behalf of the City of Maryville, because Blount County neither owns nor controls this park. The notice of appeal issue that was argued by my colleague, Ms. Wilson, applies equally to us. We were not included in the notice of appeal. I won't repeat the arguments. I do give some kudos to my good friend and colleague, Mr. Wilson, on making this joint venture argument. It's a good novel argument, but it was raised only in the Court of Appeals and wasn't raised at the trial court level. And if it had, I believe Judge Dugan would have handled it expeditiously. That it does not apply, because what that argument overlooks is the strict mandates of the Governmental Tort Liability Act, and wouldn't allow the type of vicarious liability on one partner and another partner that Mr. Wilson suggests under partnership law that applies to for-profit organizations. So I'm not going to repeat all the arguments that were made. I'll note, if I haven't learned anything else in my nearly 40 years of practicing law, and it took me a while to learn this, that you don't have to sit there and repeat the same argument over and over to the court for the court to understand it. So I'm going to leave it with the court with the appreciation that Mr. Wilson did agree this morning. He'll be fine with us being dismissed, and we'll just ask the court most respectfully to honor his request in that regard. Thank you.
Thank you very much, Mr. Garrett. Mr. Wilson, you have your 4 minutes for rebuttal.
Thank you very much. Matthew's case cited by my opponents involved a lady who fell on a defective sidewalk when she went to that facility for several reasons, one of which was to hike. And the court ruled in that case that if you enter a piece of property with the intention of performing one of those listed activities, that even though you weren't doing it yet, the statute was triggered as soon as you entered the property. That was the basis of that decision in the Matthews case. There's a parenting case. That's the one where the child was riding a bicycle. All of these cases where people have been injured and the courts have granted immunity have to do with where the person involved has a whole lot to do with the risks involved. Riding a bike, if you don't ride it carefully, you can end up in a wreck. Riding a horse is very similar to that, they say. We cite a case, McCormick versus Warren County Board of Education. In that case, the lady was walking across a football field after attending a graduation ceremony, and she fell in a hole very much like what my client did. It was covered over with grass, and the court said that the immunity didn't apply in that case, that the county had a duty to maintain this property, and that they sent it back. They indicate she should have a judgment, but they also sent it back to the trial court in that case to determine comparative fault only on that issue. But they said Warren County was responsible, and we're simply saying Alcoa and this commission was responsible for maintaining this park. And in fact, they have a duty by statute to maintain that park. And a park it's not just a piece of property out here. They've gone in and taken all the trees out, or most of them. They've sown the grass down. It's an improvement. TCA 11-24-108 says that they have a duty to maintain that property, and the other statute says they can't give that, they can't agree that that duty goes away unless somebody's fulfilling the duty to maintain that park. And obviously, it was not properly maintained.
You have about a minute left.
Thank you very much. We did bring to the judge's attention the fact that this commission was a joint venture. We did that in our complaint, the first amended complaint filed in February of 2018. And we talked about this all the way through, including the fact that they advertise on the internet that they are a joint venture. The judge heard a lot about the fact that this was a joint venture. And it is correctly, that statute says that's what this is. And they, as I say, they advertise it the same, so they're correct when they put that on the internet. And it was brought before the trial court. I believe that's about all I have to add to what's been said. I thank you very much.
Thank you, Mr. Wilson. Thanks to all of you. Give us some things to think about here. Mr. Hivner, would you recess court?
This honorable court is now in recess until 1:30 p.m.